From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Federal Trade Commission loses another antitrust case as Republicans in Congress have questions for the Justice Department attorney behind the Hunter Biden deal. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. The FTC under Chair Lina has lost another case in court, this one trying to block Microsoft's $75 billion acquisition of the video game developer Activision Blizzard. Alicia, you've looked at this. Can you take us through this? What were the arguments that the FTC made here, and what did the judge say?
So the FTC argued in this case that Microsoft would attempt to use Activision Blizzard's highly popular Call of Duty franchise. Activision Blizzard also produces a bunch of other video games, but Call of Duty is really one of its most popular ones. There's also Candy Crush, some of our audience may be familiar with. And that it would attempt to withhold these video games from other rivals, namely Sony and Nintendo, who also make consoles that compete with Microsoft's Xbox. It made some other claims about cloud computing that would also attempt to, because Microsoft is now trying to pioneer video gaming through the cloud, that it would attempt to withhold these games from other rival cloud computing companies. Now, the judge held that there was basically no merit in any of these claims, that both the evidence, including the fact that Microsoft had already agreed to make the games available to both Nintendo after the merger closed, and the games were already available to Sony. And not only that, it basically had no incentive to later basically cut its rivals off, because these games are more interactive and users enjoy them more when more people play them, and therefore actually had an incentive to expand the reach and have these games played on more consoles and other kinds of platforms, again, even with cloud computing. So the judge here ruled that Microsoft had neither the incentive to withhold these games from its competitors in quote-unquote foreclosed competition, which is really the standard under Section 7 of the Clayton Act. Interestingly, to me, the claims that the FTC made were very similar to the ones that the Justice Department made against AT&T and the Time Warner merger several years ago. If you recall, basically they claimed that AT&T, which owned DirecTV, would try to withhold highly popular, HBO content, Game of Thrones, from rivals, these small, companies like Netflix. I say that facetiously, right? They try to foreclose competition in order to boost its own DirecTV franchise. None of this came to pass, of course. In fact, AT&T ended up trying to spin off both companies. And the D.C. Circuit Court of Appeals rejected the government's, and then recall this was under the Trump administration, rejected the government's arguments there. So it's a little perplexing that Lina would try to make some similar arguments in this case that had already basically been rejected several years ago and had set a precedent.
And just to double down on that point about the test here. So the judge says, under Section 7, the government must show a reasonable probability of anti-competitive effect, unquote, in order to block this kind of acquisition or merger. And so it's not enough to show that these companies could act in a way that is anti-competitive. They have to show that they'd have an incentive to, or that they probably would do so. And Alicia, this is another in a line of cases that the FTC has been on the losing end of, one involving Illumina, the gene sequencing company, and Grail, which makes cancer tests. There was another one involving Meta, the Facebook parent, and a virtual reality company. And what is your read of this series of precedents that's being set here, and the ambition that FTC Chair Lina has to move the antitrust needle and change what has been the longtime standard, which is what is good for consumers?
Right. So a few points here. I mean, you mentioned the Illumina Grail deal. So its own administrative law judge ruled against the commission's theories in that case. And actually, there was a little bit of a similar theory in that it was trying to foreclose. This was also a vertical merger, and Illumina is basically the dominant gene sequencing manufacturer, and Grail is Cancer Blood Test startup. And basically, the FTC's theory there was that Illumina would try to hinder or hamper future rivals, because actually Grail doesn't really have any existing competitors, by jacking up the prices of tests again for those rivals in the future. And again, the ALJ in that case held that it really didn't have an incentive to do so. And not only that, it had already committed not to doing so, and actually had offered agreements to companies that were working on these tests and developing these tests that might compete with Grail someday. But the FTC, actually going back to the Microsoft case, overruled the ALJ and said, oh, we don't really care what your opinion about this. We believe that Luna has at least the incentive to do so, and it doesn't really matter as long as it has either the incentive or ability. You don't need to show both. Now, what was interesting in the Microsoft case is that the judge indirectly repudiated that. And she said here that that's wrong. You need to show that the company has both the incentive and ability to foreclose competition. And so that's teeing up a federal court case. Right now, the Illumina has gone to court in Fifth Circuit and has challenged the FTC's theories. It has also made some constitutional arguments about why the FTC's procedures are actually unconstitutional. And what I think you're going to continue to see as Lina Khan presses these kind of dubious theories, and you mentioned Meta's attempt or acquisition of Within Unlimited, and there she raised this theory of potential competition that a federal judge rejected. But as Lina Khan stretches and reaches for these more and more creative but also legally dubious theories to block mergers, you're going to see her lose more, but you're also going to see companies raise these constitutional arguments challenging the FTC's authority. And we're starting to see that again in the Illumina case, but we've also had Axon Enterprises, which actually had a procedural issue, went up to the Supreme Court, was decided earlier this year. And you're going to see more and more constitutional challenges to its authorities, which could really rein Lina Khan and future chairs and commissions in.
And that's part of what makes this subject so interesting, because here's a place where I think the old saw applies that personnel is policy. And the FTC with a different chair probably would not be pushing the boundaries of its authority in the way that we've seen it do in recent months and in recent years. And Kim, on one hand, that can be a problem for companies that are considering a merger or an acquisition or a business deal that they don't think is anti-competitive. They don't intend to be anti-competitive, but the FTC might disagree. You might have a disincentive effect there of, do we really want to spend the money to go to court to make this merger go through? Is it worth all that headache? On the other hand, we have a line of cases now here, which, as Alicia suggests, may be emboldening some of the people who are sitting in that CEO chair making that decision, since they think they might look at this track record and think they have pretty good odds in court.
Well, this has been the message from Lina Khan from the minute she took that position, which was to put everyone on notice that they were going to face a tough time if anybody tried to merge with anyone else, especially the big players in the drug industry and in the tech industry. She just has the opinion that anything that is larger is bad. And what she doesn't seem to care about is that we have a long established antitrust law and way of looking at this. We look at consumer welfare standards. We analyze market concentration. That has been on the books for a long time. And instead, in every conceivable way, she's trying to change the definitions of what counts as the right for the FTC to block a merger. And she's getting knocked down. Now, she's taking yet other steps. The FTC recently put out a new rule that's going to require companies to file a whole lot more paperwork and give more information when they propose mergers. Right now, any merger that's more than about $111 million has to notify the FTC and the Department of Justice and then wait 30 days before closing so that they have a chance to decide if they want to review. Very few of these actually go through a big review, but this new rule is going to require a ton more information than they normally have to file, including drafts of all their deal documents, identifying any overlap or acquisitions for the past 10 years, listing creditors minority shareholders and non-controlling entities. And then also listing the occupations and locations of workers, and also whether or not the firm has a history of labor law violations, because as the rule says, that may be indicative of a concentrated labor market where workers do not have the ability to easily find another job. That is all a signal to companies suggesting that the FTC is going to plow ahead here, and it's going to start looking at things like whether or not mergers involve too much labor concentration, or whether or not you have too many creditors or shareholders in common. None of this is part of antitrust law, but they are simply looking for any hook they can get to try to change those definitions, and then to try to have more reasons to block companies. And so companies may look at this string of failures and have some hope and heart, but they also have to know that the FTC seems to be entirely gearing itself around coming up with novel ways to block anything. And that is a real disincentive. It certainly is a weight on the market and a problem for free markets for that reason.
Alicia, what's your view of these new merger filing requirements that the FTC is proposing, and how heavy a lift will they be in practice for companies that are trying to get a deal done?
So right now, the mergers, it usually requires about 10 days for companies to file this paperwork. And it's not really much of a burden. But a lot of the antitrust experts that have actually commented on this proposed rule are now saying that this could take just filing the paperwork, running down all the documents, because they're now having to file documents of all the draft versions of deals that the companies went through, that this could now take 3 to 4 months. Now, that is the very purpose of what Lina Khan is trying to accomplish. Is she's trying to, one, discourage companies from even embarking on mergers, but two, just to slow them down in order so the FTC, the commission, can raise more questions, has more time to kind of start to review, and has more ammunition to sue, to block them, or to file a complaint in its administrative tribunal. Because the issue that Lina Khan faces is that there are too many mergers. The FTC doesn't have the resources right now to, or probably ever, to actually block or to actually go after and try to stop them. So she's basically trying to stop them by default by making just the process so onerous, or just, again, to slow it down so the FTC kind of has more time to review them and to lob all kinds of new questions or obstacles to them. So we'll see. Again, it's just a proposed rule. I think it's open for a public comment for 30 to 60 days. I expect that there will be all kinds of actually legal challenges if she were to go through with this, and the companies would probably raise the issues that a lot of this information she's seeking actually isn't germane at all. Kim mentioned some of the stuff like the minority shareholders and creditors that really should be a concern to the antitrust regulators under traditional and modern antitrust law. Now she argues, and the FTC argues, well, Europe collects some of this information already, and so we're just trying to mirror your procedures. But again, Europe actually has a very different framework for evaluating mergers than the U.S. I mean, it would really be a sea change if the U.S. were to go into Europe's direction, because that really is Europe's process is much more open-ended, and it does consider things other than the consumer welfare, and for instance, the effects on labor and rivals, so how a merger might affect small businesses and such. So I think that this is the first step in moving to a more European version of antitrust law. But again, it probably will get challenged in court.